Welcome back to the Real Estate Rat Pack Radio Show with Chris, Joe, and Rob. The crew is taking your calls, so dial in at 1-800-808-5548.
And we're back. Having a great time. You know, we have a caller that we told him that we were going to grab him very first thing. Bruce, how are you doing?
Doing fine, thank you. My question really goes towards the tiers or the tax increment reinvestment zones. Who has the authority under the tiers to condemn property for them? What rights do I have, and when can they come on the property to do a survey?
Good question. So did you hear that one all right?
I did. Well, as far as getting on your property to do a survey, typically when they send out that initial offer letter, they also send out with it a survey form where you're giving them permission to be on the property. If you don't grant them permission to be on the property, they can go to court and get an injunction, enjoining you from interfering with their ability to survey, because that's part of their rights to condemn. So you can make it difficult for them, but they're going to get on your property to survey. So as far as that goes, that has to happen with like the initial offer letter or the introductory letter, not even the initial offer letter, when they're first starting to figure out what they're going to offer you, et cetera. They usually send out a letter saying, we're in the area, we're thinking about doing this, we're going to be on your property. And that's a courtesy to let you know they're going to be there. The tax reinvestment zones, tax increment reinvestment zones, frankly, they had a lot of power for a while, and I don't think that they had quite as much power as they used to.
St. George Place is one of those examples.
Right. And people are challenging their ability to take on a regular basis. And so it really has to do with how they go about the process of deciding what properties to take and what to do with it.
Did that answer your question?
I think it kind of hit it on the head. Thank you.
Thank you. I think we have another call coming in.
We do have another call right behind there. We've got Vicky calling in. Vicky, how you doing?
Oh, I'm doing great today.
Oh, perfect. You have a question or a shout-out you want to do?
I want to do a shout-out to Ray at Styles Unit. Tell him that I got his letter, and praise God that he's listening to your program.
Well, thank you very much, Vicky. We really appreciate it.
Thank you. Bye.
Bye-bye. You know, time flies, like I said, and we're in the last segment with a lot of good questions that we've got right there. And, you know...
We lost Ashley. She's busting up.
Yeah,
over
we
here.
lost,
we
definitely lost Ashley right there.
We've had a good day.
I have another question for you.
Yes.
I keep rolling with this. We have to buy a business now, Kel. So because I've got
to be able to argue the point.
Yeah, just be able to argue the point. Exactly. We need to put it near a freeway or something. If we had this business that Kelsey and I were talking about, and now we get the letter, and now the government comes back and says, well, fine, we don't want to mess with your property. We're just going to go ahead and build a parking lot around it, or freeway around it, whatever. And now our business is actually messed up because of what they did. What do we do? We're sitting here twiddling our thumbs. We got no more customers because we got freeways running around our business.
That happens all the time. In fact, I have funny real estate photos in my office where you'll see 80-story buildings all around a little 1,100 square foot house. That's the one person that didn't want to sell out.
The Omni on Woodway.
There you go.
The Omni on Woodway?
There was a little old lady in the middle of all the land with Riverway and all the office buildings, and she didn't want to sell out, and she's got her little house in the middle of
But that wasn't through eminent domain, though. That was done. That was all through private purchases and things like that. So.
Same kind of concept.
But she's making out well when she wants to sell that piece of property.
Right?
Yeah, no kidding.
So what's the recourse then if our business has actually been hurt by it?
We told you to sell.
Yeah. A couple years goes by, and now y'all we have this freeway running around our little business here, and customers no longer want to stop in, and now our business has been damaged by what they did.
And that is called an inverse condemnation claim. And that is when the government does not actually go through the statutory process, but they have taken property or property rights from you for which they owe you just compensation. Now, not everything is compensable, and you have to look at the property rights that they took, and there are requirements for inverse condemnation, but those are very interesting cases, and I'm handling one right now, actually two, but they are based on the fact that the government took your property without telling you they were taking your property, and you're like, well, you can't do that. What are you doing? I mean, that's my property. And you go file a suit against them and say, you took my property without following all the right procedures, and now you owe me money.
And that actually happens still.
It does actually happen.
Now, have you ever been involved with an inverse condemnation, Frank?
Yes, I have.
And so, how do you come up with the value on that? Is it just of income stream loss, or I guess you're right. To use the property the way you wanted to use it. I mean, there's got to be some sort of valuation you got to be able to put to that.
Yeah, in all cases, what we're really appraising is property rights. We talk about real estate, but we're appraising property rights. And as we talked about earlier, when you're looking at an appraisal for something like this, you're instructed not to value it assuming the project goes in. For instance, if there's going to be some fabulous city structure that property values you think might go from $5 a foot to $30 a foot, the appraiser cannot appraise it at $30 a foot. They don't take into account the 10-year project that's going to take place. But for the same standard, they also don't take into account that if you're now backing up to a freeway, you're not damaged. They give you the value assuming that the project is not taken into consideration.
I just thought about something that I'm curious about how this plays out. Years ago, I managed a Radio Shack, and it was out on 290, and I took over the location, and shortly after, they decided to put 290 under construction there and expand the freeway. And basically, I mean, you had to go like a mile out of your way to be able to get into the parking lot. So no one ever wanted to come shopping there. They went like 3 miles away to the other store where they could get into the location easy and didn't want to mess with it. And invariably, Radio Shack ended up shutting that location down because the business just evaporated. Is there not any kind of a recourse there? Or is there any, if the business came in and said, look, because of you had eminent domain over here and you took property and did all that stuff and all that was normal and right, but because you hindered or hampered business so much over here that there's some recourse for the business owner?
Well, if that property was along the part that was taken, that would be called a material and substantial impairment of access. It used to be that you had to show both material and substantial, and it was very difficult, and security of travel was not compensable, other than as to the enhanced value, other than as a part of the property value itself. The rule changed with Senate Bill 18. They called that the Landowner Bill of Rights, and also the Appraiser's Retirement Bill, because now everybody gets an appraiser right with their final offer. But what happens is that now they've decided that no, that's too high of a standard, and material impairment of access is compensable. And so you would actually you would include that as part of the damage model when you're valuing that property, that there is a good chance that that business may go out of business, and that impairment of access did diminish the value and the marketability of that property.
Interesting. That's really fascinating. Because there was actually a number of businesses that were in that strip center that went out of business after they went under construction.
And wasn't there a lot of cases that took place actually over there in the Town and Country area whenever Beltway 8 went in? It really, before obviously we see Center and the new place in Town and Country, you had Town and Country Mall, you had the big movie theaters there, you had the old hotel there, and once they put in Beltway 8, I mean, it impacted those businesses there for a long time. Nowadays, it's a different market. Accessibility has really changed. But that time, that's an example of that mall went from being the mall in Houston to being a ghost land. I mean, almost overnight.
By trends, the mall trends are that way across the country, regardless.
But we're talking about way before that trending took place, though. We're talking about, you got to realize Town and Country Mall, we were visiting that thing way back in, the 80s.
I can tell you that it had been struggling all through the 90s.
Yeah.
So it had already economically was an unfeasible project. That's why they put HTC in there and a few other things.
I still really like that three-story mall.
Well, I understand you do it, but you know what? Malls have gone the way of the dodo bird. So.
Yes, I agree.
But so then you have to kind of figure out what part is diminished value caused by the condemnation and what part is market trends. And so you got to kind of separate those two.
Well, again, and that's why it's the battle of the experts, because as Frank mentioned, appraisals are not exact sciences. They are art forms. There's a blend between art and science.
It's an opinion
of value. It is
Picasso.
It is an opinion of value, and people differ in opinions, and the things that they consider are important. And you also have to look at it from the perspective of a jury. What is a jury going to say that three-story mall is worth if it's, if it's there and built?
That brings me to the question, what would you prefer, a jury or a judge?
On a
and you're working as the attorney, not the judge.
I'm going to go with the jury. You know, there was a study done that said that if you put 6 people in a room with varied backgrounds, that number, more times than any other number, comes out with the right answer. And that I read that shortly after I took the bench many years ago as a judge, and we have 6 panel jurors in county court at law. And that's the right number. When those 6 people get in the room and they've listened to the evidence and they go back and they start talking and going through the process, I have a lot of confidence that those 6 people can come up with the right answer.
That's a good thing to know. Of course,
that is really good to know.
A very different perspective than a judge would do it, because they're single-minded.
And there are 6 of us right here in the room right now. It means that we are the perfect amount of people that can make a decision, by the way.
We're coming kind of against that time again.
We are coming against that time.
I want to ask the good judge, what would you like to leave with the people?
Well, what would you like to have? What message would you like to leave the people with?
Yeah, the peoples.
Well, if you are facing a condemnation situation, I do think you should find yourself a lawyer, and I do think that it should be a lawyer that practices in the area and has a good command of that area of law, because it is a specialty. It is not something that you go to a lawyer that handles homeowner association cases because they're your regular lawyer and they handle your stuff and it's part of what's being taken. You need to go to a condemnation lawyer to handle a condemnation case.
And how do people get a hold of you?
I have my website is luccismithlaw.com, LUCCI Smithlaw.com, and my phone number at the office 832-494-1700.
And Frank, same question to you.
Question. What do you want people to know?
I think what I would point out is there was a study done, a famous study, a very simple study done either at Harvard or Yale, and it was about a coffee mug, and they produced coffee mugs and handed it out to the people in undergraduate class, and what they found out is those that got the coffee mugs, which was about half the class, thought the coffee mug was worth about $7. Those that didn't get it said they'd give $4 to it. And that study applies to cars, houses, businesses, and everything else. The gap between what you think it's worth when you own it and what somebody else on the street might be willing to pay is why the appraiser is there to close the gap.
How can we get a hold of you?
281-596-0066.
Great show as usual. One of the things we want to do is leave a great quote, and today is no different. Government has no other end but the preservation of property. That's from John Locke, by the way. John Locke, by the way. So until next... You quoted that in your brief, right? Time flies, you're having fun. We are done for this week. Until next week, we are out.
And you've been listening to the Real Estate Rat Pack. The question is, who's Frank, who's Sammy, who's Dean, and who's the other guy?
Chris is Frank, he's Dean, and I'm Sammy.
Yes, that's right. Yeah.
So tune in to the really big show every Saturday at 9 a.m. right here on 100.7 The Word, KKHT.